Hello, this is Jonathan Riley of Lawrence Graham welcoming you to our webinar on limiting liability. This webinar is presented by Lawrence Graham's Commerce and Technology Group as part of our SmartLaw program, and I'm joined today by my colleagues and fellow group members, Alex Beale, Vanessa de Frobeville, and Richard Mark. Limiting liability is a big topic, and so we've chosen today to focus on a number of specific aspects: the regulatory framework, some of the circumstances in which no limitations on liability might arise, and the lessons to be learned from arguably the two biggest cases of this area in the last 18 months. However, if you see that there's strong interest in other aspects of this subject coming through in your questions, then we plan to arrange a follow-up event to look at these aspects. The format for this webinar is that we'll have 4 presentations, each of somewhere between 10 and 15 minutes, and then we'll conclude with a Q&A session and aim to close in around an hour's time. You'll see from the slide on your screens at the moment that there's a dialog box for you to submit any questions at any time during the presentations. We'll receive and collate those questions and then discuss the most popular questions and issues arising in the Q&A session at the end of the presentations. I would add, though, that we do have around 100 participants registered for this session, and so I apologise in advance if we haven't addressed all of the questions sent in by the end of the Q&A session. Now I'm pleased to start our presentations by introducing Alex Beale to discuss the regulatory framework. Alex.
Thank you, Jonathan. Now I've got a good dose of black letter law for you this afternoon, and we are going to look at the most important legislative provisions relating to exclusion clauses. For those of you that don't know, an exclusion clause is a clause in a contract which seeks to limit or exclude liability for a specific occurrence. Over the next few minutes, we are going to consider the most important legislative provisions relating to exclusion clauses, which are the Unfair Contract Terms Act 1977 and the Unfair Terms in Consumer Contracts Regulations 1999. So turning to the Unfair Contract Terms Act 1977, or UCTA as it is affectionately known, UCTA predominantly governs exemption clauses in contracts. It makes some clauses ineffective in all circumstances and others only effective if they comply with the requirement of reasonableness. Different controls apply according to the nature of the liability which the parties wish to exclude and the relationship between the parties. So in other words, whether you are dealing with a business or a consumer will largely govern the outcome of whether a term can be excluded or not. Therefore, we need to consider a few preliminary definitions before getting down to the nitty-gritty of the Act. UCTA defines business liability as liability for breach of an obligation or duties arising from things done or to be done by a person in the course of a business, which will include a profession and the activities of any government department or public authority. So the term business liability is broadly defined. UCTA defines a person dealing as a consumer if they do not make the contract in the course of a business and the other party does make the contract in the course of a business. So generally, we will always have a contract made either between two businesses or a business and a consumer. UCTA imposes a reasonableness test on certain contractual terms. Therefore, the other definition we need to consider before we tackle the Act is what is considered to constitute reasonableness under the Act. Section 11.1 of UCTA states that in order to pass the reasonableness test, a contract term must have been a fair and reasonable one to be included, having regard to the circumstances which were or ought reasonably to have been known to or in the contemplation of the parties when the contract was made. In other words, whether or not something is reasonable will be context-specific, not particularly illuminating from UCTA. However, further non-exhaustive guidance about the term reasonableness is set out in Schedule 2 of UCTA. The guidelines are, in summary, that the strength of the bargaining positions of the parties relative to each other must be considered. Disparity of bargaining position is more likely to result in an inference of unreasonableness being drawn. Whether any inducement was given to the customer to agree the term, whether the customer knew or ought reasonably to have known about the existence of the term, whether the goods were manufactured, processed, or adapted to the special order of the customer. It is also worth bearing in mind that these guidelines are by no means exhaustive. It would simply be impossible to draw up an exhaustive list of factors to be taken into account to decide what would constitute reasonableness. The case of St Albans City and District Council and International Computers Limited, full reference is up on the slide there for you, highlights the types of factors that may be considered. In this case, ICL provided a computer system to the St Albans local authority for use by the authority in collecting the community charge. As a result of a fault in the software, the authority set the charge at too low a level. The authority sued ICL for over £1 million in damages for breach of contract. ICL sought to rely on a clause in its standard terms of business, limiting its liability to £100,000. Both the High Court and the Court of Appeal held that the limit of £100,000 was unreasonable under UCTA, having applied the Schedule 2 reasonableness test. The key point highlighted by this case is that when UCTA imposes a reasonableness test on a contractual term, it must be a fair and reasonable one to include, having regard to all circumstances of the contract. A term that is reasonable under one contract may not be so under another. Now that we have considered these preliminary definitions of business, consumer, and reasonableness, let's take a look at a few specific provisions of UCTA. As we said before, different controls apply according to the relationships between the parties. We will first look at exclusion clauses in the context of business-to-business relationships. The first provision up on the slide relates to excluding or limiting liability for death or personal injury resulting from negligence. By virtue of Section 2.1 of UCTA, a business is absolutely prohibited from including this type of clause in a contract. On the other hand, a business-to-business contract may be able to limit liability for negligence as long as the negligence did not result in death or personal injury. Under Section 2.2 of UCTA, a term excluding or restricting liability for negligence is enforceable and acceptable provided that it satisfies the reasonableness test. What else are we prohibited from excluding in business-to-business relationships under UCTA? UCTA contains specific provisions relating to limitations and exclusions of terms implied by the Sale of Goods Act 1979. Now, the Sale of Goods Act imposes implied terms into contracts for the sale of goods, including good title. Section 12.1 of the Act asserts that the seller has the right to sell the goods. Section 12.2 of the Act asserts that the goods are free from undisclosed charges or encumbrances and that the buyer will enjoy quiet possession of the goods. A term excluding or restricting liability for these implied terms is wholly ineffective, and it is Section 6.1 of UCTA that states this. The Sale of Goods Act also imposes a number of additional implied terms in contracts for the sale of goods which may be acceptable to exclude depending on the reasonableness of such a clause. Correspondence with description. Where goods are sold by description, there is an implied term that the goods will correspond with that description, and that is Section 13. Satisfactory quality. Where goods are sold in the course of a business, there is an implied term that the goods are of satisfactory quality, and that is Section 14.2. Fitness for purpose. Where goods are sold in the course of a business and the buyer makes known to the seller the purpose for which he wants the goods, that the goods will be reasonably fit for that purpose, and that is Section 14.3. Correspondence with sample. Where goods are sold by sample, there is an implied term that the goods will correspond to the sample in quality, and that is Section 15. A term excluding or restricting liability for any of these implied terms is enforceable only to the extent that it satisfies the reasonableness test as between business to businesses, and it's Section 6.2 and Section 6.3 of UCTA which states this. Can a business-to-business contract seek to exclude or restrict liability for breach of contract? These exclusions may be valid in an individually negotiated contract between two businesses, but if the parties are contracting on one party's written standard terms of business, the terms are enforceable only to the extent that they satisfy the reasonableness test, and it is Section 3 of UCTA that states this. Now, that was a very quick canter through some of the provisions of UCTA which relate to business-to-business contracts. Now let's take a look at provisions of UCTA that apply when you are dealing with a consumer. As we said before, under UCTA, a business cannot exclude or restrict liability for death or personal injury caused by negligence. This also applies as against a consumer. The position is the same in relation to the implied terms of good title and no encumbrances implied by the Sale of Goods Act. In other words, these terms cannot be excluded. Any attempt to do so will be ineffective. As one would expect, the legislative framework provides more stringent safeguards for consumers than businesses, and so in addition, an exclusion of the implied terms in contracts for the sale of goods relating to correspondence with description, satisfactory quality, fitness for purpose, correspondence with sample, are also wholly ineffective as against a consumer. The reasonableness test is of no relevance in these instances. In addition to these provisions, you'll need to consider a second piece of legislation when dealing with consumers, the Unfair Terms in Consumer Contracts Regulations 1999. These regulations apply to contracts with consumers, but unlike UCTA, they cover more than those terms which simply limit or exclude liability. An unfair term under the regulations is said to be one which has not been significantly negotiated and which, contrary to the requirements of good faith, causes a significant imbalance in the parties' rights and obligations under the contract in favour of the seller or the supplier. This is Regulation 3 of the regulations which states this. The regulations also refer to an indicative and non-exhaustive list of terms which may be considered unfair, and these are set out in Schedule 2. Now, I've set out on the slide some examples of what could potentially be considered to be unfair terms. I won't run through all of these now, and will leave you to read the examples at your leisure. However, in summary, the regulations set out a requirement of good faith and embody a general principle of fair and open dealing. It requires a supplier not to take advantage of the consumer's weaker bargaining position or lack of experience in deciding what their rights and obligations shall be. Now, that was a very brief overview of the regulatory framework. I'm now going to hand over to Jonathan, who will take you through the concept of unlimited liability in contracts.